Enter in. Is that enter?
Max, are we ready to start?
Um, uh, as long as we have enough members.
Okay. I see Douglas, I see John, I see Krista, I see Raghu Kota.
Hi.
Hello, did I pronounce your name correctly?
Yep, it's Raghu. You could go by Raghu.
Raghu? Okay.
Thank you.
I got lucky. I got lucky then. Welcome
Yeah.
on the board.
It's easy to remember, sauce Raghu.
Okay. Yeah. All right. Looks like we have 6 board members, it looks like, counting myself. Max, we want to go ahead and get started then? How about you? I mean, do you have, is Cherie there? And I saw Jill was on.
I saw Jill is on. I don't see Tree yet. She is on. I see her. And I think
Good
we're up and
morning.
running.
So the only one we're missing is Thomas. But we don't need Thomas until the last case.
That's correct.
Yeah. Can you hear me?
Yes.
Oh, thank you. I'm so happy. I appreciate it.
So you want to go ahead and get started, Max and Shad?
I think we're ready.
All right. The March 2021 meeting of the Charlotte Zoning Board of Adjustment is now in session. I am Rick Sanderson, the chairperson. Also sitting on today's board is Deborah Dryden, Krista Long, Douglas Wilson, John Floyd, and Raghu Kota. We may also be joined by Patrick Welch, the vice chair, and Marshall Williamson, if they're available. Also present are Shad Spencer, the zoning administrator, Lisa McCarter, planning project manager, Cherie Hagler-Gray, senior assistant city attorney, Jill Sanchez-Myers, senior assistant city attorney, Max Oliver, clerk to the board, Atkins Court reporting verbatim reporter, and we will also be joined by Thomas Powers, senior assistant city attorney. I would like to start, excuse me, by acknowledging that we are conducting this meeting using a remote electronic format. This is the 10th remote meeting of the Charlotte Zoning Board of Adjustment, and I would like to ask for your patience today as we proceed. As we proceed, there may be slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustments is a quasi-judicial body that is governed by the North Carolina General Statutes and the Charlotte Zoning Ordinance. We conduct evidentiary hearings on requests for variance and appeals, among other requests. Before we begin to hear cases today on today's agenda, I would like to provide some important information on the steps that were taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by the North Carolina General Assembly in Session Law 2020-3 that allow for remote meetings and quasi-judicial hearings during declarations of emergency. Second, each applicant was notified before being placed on today's agenda that this meeting would be conducted using a remote electronic platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on their request using this remote platform. Third, notice of this meeting was provided to the applicants in public in a number of ways. Notice of today's hearing was mailed to property owners within 300 feet of each subject property and notified the property owners of the remote electronic platform. And the letters also stated to contact the city immediately if there were any objections to the cases being heard on today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notices for today's meeting contained information about means by which the public can access today's proceedings. Finally, any individual wishing to participate in today's evidentiary hearings were required to sign up prior to today's proceedings. This information was also included on the board's website. Today we'll be hearing one type of case, an application for a variance from the regulations in the zoning ordinance. Application for a variance from the regulations in the zoning ordinance, the order of recommendation agenda will be as follows. The zoning administrator or a zoning staff member will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions for staff or if there is any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the regular agenda will be as follows. All parties who plan to give testimony pro or con must be sworn in. The zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for their case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses, but they will be subject to questioning. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, March 29th in order to be considered at this hearing. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for purposes of this hearing and can only accept sworn testimony. While the board will not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another at quasi-judicial hearings on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform function to message the clerk. The documents will be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such request at the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the day of the board's written decision in which to appeal, in accordance with North Carolina General Statute 160A-388E. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. We will be hearing 6 cases today, 3 recommendation agenda items, 3 regular agenda items. The first case is number 2021-009 for the property located at 1001 Harrell Avenue, presented by Lisa McCarter. Max, is there anybody who opposes this case?
No one has signed up to speak that opposes the case, but there are 2 call-in users, so I'm not sure which cases they are here for.
Okay. Well, all those, so Lisa and Shad, all those who plan to give testimony affirm the following. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
I do.
Okay, and I'll swear in any others as we get moving forward. So let's go ahead and get started, Lisa.
Okay, our first case is case number 2021-009. It's a residential rear yard variance. The applicant is requesting a 16-foot variance from the 35-foot minimum required rear yard to construct a single-family home on the property, and I'll give you a minute to look at your findings.
Before we get started, since we have so many board members today, let's go ahead and set up the board who will be listening to this case. It'll be myself, Ms. Dryden, Ms. Long, Mr. Wilson, and Mr. Floyd will be the 5 board members for this case. Go ahead, Lisa.
Exhibit number 1 is the vicinity map of the subject property. Exhibit number 2 is the zoning map. The zoning is R5 single family, and directly across Van Every Street, there's some UR2 CD. That's a conditional zoning district. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. You can see that the property is a vacant property and it's located on the corner. Exhibit number 5 is background. The lot was created prior to 1989 according to historic zoning maps and is approximately 4,120 square feet. That doesn't meet the 6,000 square foot minimum lot size required in the R5 zoning district, but since the lot predates the current zoning requirements and does not meet the minimum lot size, it does meet the definition of a non-conforming vacant lot. The lot is permitted a single-family detached dwelling if the setbacks, yards, height, and parking requirements are met. Slide 6 is the variance request. The required setback for the property is 20 feet, and the required rear yard is 35 feet. The lot is approximately 82 feet in depth, so the application of the required setback in the rear yard create a permitted building depth of approximately 27 feet. The applicant is requesting a variance of 16 feet from the 35-foot rear yard for a 19-foot rear yard that would permit them a building depth of 43 feet to construct a single-family home on the property. Slide 7 is considerations. Staff supports the requested variance. The hardship results from conditions that are peculiar to the property because the lot size is smaller than other lots in the area. The requested building depth is consistent with other R5 building depths in the area that are 43 feet and greater, and you can see the building depths in the little boxes on the lots themselves. The hardship was not caused by the applicants because the applicants purchased the property as it currently exists. Granting the variance will not change the character of the area. The lot predates the current zoning ordinance requirements. A variance was granted for the adjacent property in 2018 to permit a 10-foot setback and rear yard. So you can see that called out, it's variance 2018-70. Granting the variance will not impact public safety because the 20-foot setback will not be varied, and it will accommodate compliant driveway length and parking. Exhibit number 8 is a photo of the vacant property. And that's the end of my presentation. If you have any questions for me.
All right, thank you, Lisa. So, Max, there's no one, is there anybody to speak in opposition to this case?
No one has signed up to speak in opposition to this case.
All right. I didn't know if you'd find out who the other two people were, so, okay, thank you. Is there any questions from the board for staff?
Lisa, this picture that we're looking at right now, does that, I'm sorry for the echo. I don't know how to get rid of that. Is that the front of the lot or the side of the lot?
This is the front of the lot.
Okay, thank you.
Any other questions from the board? If not, is there a motion?
I make a motion to accept the variance, Dryden.
And I second the motion, Wilson.
Okay, we have a motion by Mrs. Dryden and a second by Mr. Wilson to approve the variance for this case. Let's take a roll call vote. Mrs. Dryden,
Dryden, yes.
Mr. Wilson,
Wilson, yes.
Mr. Floyd,
Floyd, yes.
Ms. Long,
Long, yes.
Sanderson, yes, so it's approved. Let's look at the findings of fact and conclusions of law. I don't see anything.
I make a motion to approve the finding of facts and conditions of law as written. Dryden.
Floyd seconds.
Okay, we have a motion by Mrs. Dryden and a second by Mr. Floyd to approve the findings of fact and conclusions of law as written. Let's take a roll call vote. Mrs. Dryden,
Dryden, yes.
Mr. Floyd,
Yes.
Ms. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Anderson, yes. So those are approved. All right. The next case is case number 2021-10 for the property located at 2808 Shenandoah Avenue. And I understand Mr. Floyd has a conflict on this case. Is that correct?
Yes, that's correct.
All right, so Raghu, you get to participate in this case then. Did Mr. Welch ever join, Max?
Yeah.
Sorry?
He has not joined as far as I'm aware.
Okay,
No, he is on the call. Yes.
so for this case, we'll have myself, Mrs. Dryden, Ms. Long, Mr. Wilson, and Mr. Kota. Mr. Kota, you have been sworn in, correct, by the clerk?
Yes, I did.
All right. And you'll be sitting on this case then. Go ahead, Lisa.
Thank you.
Okay, this case is case number 2021-10. It's a residential lot area variance. The applicant is requesting a 1,326 square foot variance from the 8,000 square foot minimum lot size to construct a single family home on a property. And I'll give you a minute to look at your findings.
Okay, Lisa, let's go ahead, please.
All right, exhibit number 1 is a vicinity map of the property. Exhibit number 2 is the zoning map. The zoning is R4 single family and it abuts next to the East Independence Boulevard right away. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. The property is currently vacant. Exhibit number 5 is background. The lot was platted on June 1st, 2020. The plat was not subject to the subdivision ordinance regulations because it was a recombination of 4 existing lots from a previous 1946 plat. And you can see that over on the left-hand side, the 4 lots that it used to be. The property is 6,674 square feet, which is not compliant with the 8,000 square foot minimum lot area required to construct a detached dwelling in the R4 zoning district. Slide 6 is the variance request. The applicant is requesting a variance of 1,326 square feet from the 8,000 square foot minimum lot area to permit a detached dwelling on the property. Slide 7 is considerations. Staff supports the requested variance. The requested variance for a 6,674 square foot lot is in keeping with the character of the area and is not easily detectable here. Other requested lot areas are consistent in the area because they range from 6,272 square feet to about 9,278 square feet. And you can see the square footages in the little boxes on the lots. Exhibit 8 is further considerations. The hardship was not created by the applicants. The lot was recently created through an approved recombination plat, not subject to the subdivision ordinance. The applicant became aware of noncompliance when they applied for a variance request on the adjacent lot. The hardship results from conditions peculiar to the property. The original 4 lots on the 1946 plat were approximately 9,420 square feet each. The lot area was decreased when Independence Boulevard right-of-way was acquired. A single-family dwelling would not be permitted on the property without the requested variance. The requested variance will not impact public safety. Exhibit number 9 is a photo of the vacant lot. And that's the end of my presentation. If you have any questions for me.
Thank you, Lisa. Are there any questions for staff? Max, is there anyone signed up to speak in opposition to this case?
No one has signed up to speak in opposition to this case. One neighbor voiced support, but I do not believe they are on the call.
Okay, thank you. If there are no questions from the board, is there a motion?
I make a motion to approve the variance, Dryden.
I make a motion to second.
Okay, we have a motion by Mrs. Dryden, a second by Ms. Long to approve the variance. We'll take a roll call vote. Mrs. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mr. Cota,
Kota, yes.
Sanderson, yes. So it is approved. Let's look at the findings of fact and conclusions of law. I didn't see anything.
I make a motion to approve the finding facts and conclusions of law. This is Wilson.
Dryden, I'll second.
Okay, we have a motion by Mr. Wilson and a second by Mrs. Dryden to approve the findings of fact and conclusions of law as written. Let's take a roll call vote. Mr. Wilson,
Wilson, yes.
Mrs. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Mr. Cota,
Kota, yes.
Sanderson, yes. So those are approved. Our next case is case number 2021-024 for the property located at 3252 Foxcroft Road. For this case, it's myself, Mrs. Dryden, Ms. Long, Mr. Wilson, and Mr. Floyd. Nobody has any conflict of interest on this case, correct? All right, hearing none, that's how we'll proceed. Go ahead, Lisa.
The next case is case number 2021-24. It's a residential rear yard variance. The applicants are requesting a 27-foot variance from the required 45-foot rear yard in order to construct an addition on an existing home. And I'll give you a minute to look at your findings.
Go ahead, Lisa.
Exhibit number 1 is the vicinity map of the property. Exhibit number 2 is the zoning map. The zoning is R3 single family. Exhibit number 3 is an aerial map of the property. The property is a corner lot located on Foxcroft Road and a Foxcroft Road cul-de-sac. Exhibit number 4 is a close-up aerial of the property. Exhibit number 5 is background. The lot was created in 1952 and the home on the property was built in 1956. The R3 zoning district requires a rear yard of 45 feet, and the home on the property is non-conforming because it predates the rear yard requirements and has an established rear yard of 18 feet. Exhibit number 6 is the variance request. The applicants would like to add a heated addition onto the rear of the home and are requesting a variance of 27 feet to utilize the established 18-foot rear yard. So you can see the blue line is the 18-foot established rear yard and also what they're requesting for the addition. And the red line is the 45-foot required rear yard. Exhibit 7 is a consideration. Staff supports the requested variance. The applicant states that the proposed location for the master bedroom addition is tied into the existing layout of the home. So you can see in the darker area is where the master suite will go, near the bedroom area. Exhibit number 8 is the consideration of 2 large mature trees located in the street side yard along Foxcroft Road. The applicant has provided an arborist letter stating that construction in this area would compromise these trees. So you can see the trees in this photo. Exhibit number 9 is additional considerations that the hardship results from conditions that are peculiar to the property because the existing home is oriented diagonally towards the intersection, reducing the rear yard area. The hardship was not caused by the applicants because the home was built in 1956, predating ordinance requirements, with a non-conforming established rear yard of 18 feet. Granting the variance will not change the character of the area. The addition to the rear of the home maintains the existing streetscape of the street side yard along Foxcroft Road because other homes along the street have established setbacks of over 40 feet. So you can see that labeled on the lots. The subject lot has 35 feet between the home and the right-of-way, and then there's greater distances going down the road. The addition will not be easily detectable because it will be in the interior corner of the lot, and granting the variance will not impact public safety. Exhibit number 10 is a photo of the property. And that's the end of my presentation. If you have any questions for me.
All right. Next, is there anyone signed up to speak in opposition to this?
No one has signed up to speak in opposition to this. One neighbor is in attendance, and I will unmute them. They did not voice opposition, though, just interest in the case.
Okay. Are there any questions for staff from the board?
Oh, I'm sorry. Lisa, this is Douglas Wilson. This is a picture of the front of the yard, right? Because I know that your presentation said that the new addition is going to be in the rear of the yard. I don't know if Lisa heard me.
Sorry, I was muted and I didn't realize it. Okay, yeah. If you look along to the left is the street side yard along Foxcroft, and then the front of the property is actually to the left. I mean,
Okay.
to the right, sorry.
Right, got it. Okay, okay, got it. Okay. Thanks.
But
This
I
is
just want to
Krista. So
clarify,
the-
Lisa, the new building is not going to, it's still going to stay within what the old boundaries were, what the original house was built as, right?
Correct. I'm turn it back to slide 6.
Right.
And you can see that the addition is not exceeding the established 18-foot rear yard.
Okay, thank you.
Lisa, this is Rick. So this approval of this variance will set the new rear yard at the established rear yard depth, correct? For the whole property?
Correct.
Okay. Are there any other questions for the staff? Is there a motion?
Dryden, I make a motion to approve the variance.
Mr. Chairman, before we go to second, does the applicant, should the neighbor speak first or can they speak after we vote?
Sorry?
I know that Max said there's a neighbor that wanted to speak, in regards to this. I know they didn't want to speak in opposition.
It was, no, it was a speaking in support, or just for information's sake.
Okay. Well, in that case, I second.
Okay. Thank you. We have a motion by Mrs. Dryden, a second by Mr. Wilson to approve the variance. Let's take a roll call vote. Mrs. Dryden,
Dryden, yes.
Mr. Wilson,
Wilson, yes.
Ms. Long,
Long, yes.
Mr. Floyd,
Floyd, yes.
Anderson, yes, it is approved. Let's look at the findings of fact and conclusions of law. I didn't see anything.
I make a motion to approve the findings and facts and conclusion of law.
I second.
Thank you. Thank you. We have a motion by Mr. Wilson and a second by Ms. Long to approve the findings of fact and conclusions of law as written. Take a roll call vote. Mr. Wilson,
Wilson, yes.
Ms. Long,
Long, yes.
Mrs. Dryden,
Dryden, yes.
Mr. Floyd,
Floyd, yes.
Sanderson, yes. So that's approved. Our next case, we're done with the recommendation agenda and now we're moving into the regular agenda. Our next case is case number 2020-131 for the property located at 901 East 19th Street. Is there any conflict of interest on this property? Okay, hearing none, then the board members will be myself, Mrs. Dryden, Long, Mr. Wilson, and Mr. Floyd. You can go ahead, Lisa.
Okay, this case is 2020-131. It's a residential setback and rear yard variance. The applicant is requesting two variances to construct a single-family home on a non-conforming vacant lot, a 10-foot variance from the 20-foot setback, and a 25-foot variance from the 35-foot rear yard. And I'll give you a minute to look at your findings.
Okay, Lisa, let's proceed, please.
Okay, exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The zoning is R5 single family, and it's adjacent to some R22 multifamily. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. The property is currently vacant. Exhibit number 5 is background. The lot was created prior to 1989 as is approximately 2,613 square feet, which doesn't meet the 6,000 square foot minimum lot size required in the R5 zoning district. Since the lot predates the current zoning requirements and doesn't meet the minimum lot size, it meets the definition of a non-conforming vacant lot. The lot is permitted a single-family detached dwelling if the yard's setback, height, and parking requirements are met. Exhibit number 6 is the variance request. The required setback for the property is 20 feet, and the required rear yard is 35 feet. The lot is 50 feet in depth, so the application of the required setback and rear yard create an overlap of 5 feet and no permitted building depth, as you can see to the graphic to the left. The applicant is requesting a variance of 10 feet from the 20-foot setback to allow a 10-foot setback, and a variance of 25 feet from the 35-foot rear yard for a 10-foot rear yard to permit a building depth of 30 feet to construct a home on the property, and you can see that in the graphic on the right. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship results from conditions that are peculiar to the property because the lot size is smaller than other lots in the area, and no building depth is permitted without a variance. Other lots in the area are around 7,000 square feet. The hardship was not caused by the applicants because the applicants purchased the property as it currently exists. Granting the variance will not change the character of the area because the lot predates current ordinance requirements. Granting the variance will not impact public safety because the alley that runs adjacent to the left of the property line will accommodate compliant driveway length and parking. Exhibit number 8 is a photo of the subject property, and you can see that the property is vacant, and you can also see the graveled alleyway to the left side of the property. That's the end of my presentation. If you have any questions for me, and I'd also like to let you know that the applicant has prepared a presentation.
Okay, thank you. Are there any questions from the board right now for staff?
I have one question about the parking. I don't know how to get rid of the echo, I'm sorry. The driveway is actually going to be the alley. What about the alley for the rest of the, I mean, the alley runs a long way down the street. Does anybody else use that alley?
They'll use that alley for a portion of their access. The actual parking would need to be on the property.
Okay, thank you. So I wonder within this 2007, where would the parking be then? In that 10-foot rear yard or the 5-foot side yard?
I would have to defer to whatever the applicant's plans are. They would have to use that. They can use the alley. The driveway needs to be at least 20 feet in length to accommodate parking.
Okay, hopefully the applicant's presentation will clear that up. Thank you.
Thank you. Are there any other questions for staff right now? All right, Mr. Murray, are you going to have anybody else speak during your presentation? I need to get sworn in.
Yes, sir. My client, Carl Spielvogel, is the representative with me today.
All right, will you please have them on my right piece of paper? For the ones on your presentation that you want to speak, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, and before you speak, please state your name and your address for the court reporter.
Carl Spielvogel, 901 Sweetbriar Street, Charlotte, North Carolina.
Thank you. All right, Mr. Moore, you can begin.
Thank you. Members of the board, thank you for hearing our case this morning. Staff, I appreciate your support, and I agree with the proposed findings that the city has proposed, as well as the report. My name is David Murray. I'm an attorney with the Odom firm in Charlotte. I represent the Charlotte Real Asset Fund Trust, which is the owner of this property. And again, Carl is with me here today. Carl, I want to confirm with you real fast that you have reviewed this PowerPoint presentation and it is true and accurate to your knowledge.
Yes.
Thank you. Lisa, can you move forward? We are seeking variances here so that we can construct a single family house on the lot. Actually, up until the 1980s, there was a single family house already on this lot, but it fell into disrepair. I did a title search, and in the 80s, as part of the federal government's urban renewal projects, this property was purchased, and it appears that the house was torn down at that time. So since that time, there has not been a house. I believe it was approximately 1982, 1983. Lisa, can you move forward? There is a lot of precedent for a variance on a lot this size. Just in the cases that I knew off the top of my head, which I was involved with, I think 4 out of 5 of these, this board has granted similar variance requests. The Beckwith property is smaller than this parcel, and the Walford property is smaller than this parcel. And so this request that we're doing is not only in line with the neighborhood, it's also in line with what this board has approved in the very recent past. A lot of this is driven because there's a shortage of lots to be built on in Charlotte. And so these smaller lots that require variances to be built on are now in much more demand for construction. And so the case numbers are there as backing for these cases. You can move forward. These are aerial pictures of the other lots that obtain similar variances. The Van Avery Street, you can see there that a variance was granted. A house was built, and the alleyway was used actually as the driveway and the parking area. The Van Avery lot is narrower than this lot is. And so I think it's also a smaller lot. So I think that was probably the only place, but you can see there, the house was constructed, the alleyway was used for parking and for access. The Beckwith Place property is a variance that I obtained with a lot frontage similar to the lot we have here. And on that property, the parking is just to the right of the house. And so that house is actually only 8 feet from the front setback. The Yadkin Avenue lot does not have a house constructed on it yet. It has no alleyway next to it. The 17th Street, this was the same client that we are seeking a variance on today. We obtained a variance on that lot. Obviously, it's a wider lot in the front, but it has an alleyway to the side also to provide driveway access into the property. And then the Walford Drive variance, which is the bottom right, is also the same client. And we are about to go under construction on that property. A house will be built, and the alleyway will provide the ingress, egress, and some parking area. Although that lot is smaller than this lot, that builder has been able to go through approval and have the sufficient parking. Please move forward. As you can see, this was in the city's presentation, but as you can see, the front and rear setbacks that apply to this property would overlap completely such that nothing can be constructed. It's important to note here that we're not seeking a side yard variance. So the 5-foot side yard applies to this property regardless of whether there's a variance or not. So the property owner to the right of this property has a 5-foot side yard regardless of what we're seeking to do here. So this is just simply for the front and for the rear. If you can move to the next slide. And in order to provide an area to be able to put a house that's marketable, we're seeking a 10-foot front and rear reduction, which we also, when we do these type of variances, we go look at the existing houses on the street to see how far they're set back. And we also look at previous variances that have been approved by this board. And so in this case, in order to be able to build a house and be able to have enough depth in the house, given that the house is going to be limited to essentially 30 feet, that is a pretty reasonable size depth for the houses in this area. Also on this map, what you can see is that we have a 55-foot wide a lot, and that would provide sufficient space to either park in the rear of this property or essentially along the side of the alleyway. We can park in the side yard, and it's highly unlikely a house would be 45 feet wide that's on this property. We don't have the exact house plan at this point, but the Walford Avenue variance that was obtained was actually for a smaller lot. We anticipate that's going to be the same builder, and they're moving forward on construction on that property. So we don't anticipate any issue here. The alleyway is graveled, and it's not in use by anybody else that's on this, that's in this area. It's only in use because I think it's been just graveled that way for years and years, and the aerial images also show that. If you can move forward, please. Just to review, as I always do, the variance standards that the Board of Adjustment shall vary the provisions of the zoning ordinance upon a showing of all of the following: unnecessary hardship, conditions peculiar to the property, did not result from actions taken by the applicant or the property owner, and consistent with spirit, purpose, intent of the zoning ordinance such that public safety is secured and substantial justice is achieved. If we can move forward, please. Under the unnecessary hardship, if a variance isn't granted, this property cannot be built upon. And so it'll just sit there, and it'll be a dead lot, and nothing can be built upon. The lot was originally subdivided. I personally did the title search on this property. The lot was subdivided in approximately 1977. Before and after that, though, a house was constructed. The house was constructed in the 1950s. It appears that, given that back in the 1950s, zoning didn't apply the same way, it appears that they had 2 houses on this property. And when it came time to subdivide the lot, they subdivided off the rear portion of the lot in order to allow that other house to be its own lot. And like I said, existed there up until the 1980s when it was a bank working for the federal government through the HUD program for urban renewal that purchased this property and removed the house. Again, other similarly sized lots have been granted, variances, and unnecessary hardship has been found on those lots. Please move forward. Believe it or not, we actually had an aerial from Mecklenburg County showing this house in 1956. So it did show, and the strangest thing is the aerials from the 80s are incredibly blurry, but the aerial from 1956 is more clear than the aerials from the early 90s. So I don't know what happened there with our photography, but I guess there were probably some good pilots after World War II that went into business and started taking pictures of aerials. And as you can see here, there is a house on the back of this property. The house actually also predated all the infill construction around this property. So at the time when this house was built, it was only this house, a house on the corner, and then it was vacant land all around it. So by the time that this house was torn down in the 80s, all the other houses around this house had been built. If we can move forward. The hardship here runs with the land. It's not personal. It's not personal to my client. It's not personal to any client. Any owner is going to have this problem. It's directly related to the subdivision in the 1970s to separate two pre-existing single-family residential houses. Although similar variances, like I pointed out, have been granted, the size of this lot is not typical for this street or this general area. And the need for the variance is directly related to the small size and shape of the lot. We can move forward. Thanks. It's not a self-created hardship. The applicant here did not create this. The previous owner did not create this. It was done, like I said, back in the 1970s between the original owner of the corner lot and the original owner of this lot. Please move forward. Under the public safety and substantial justice, what we look at, really what we're looking at here is, does this variance provide for the intent of the ordinance? And the intent of the ordinance is organized development. So the intent is to provide setback rules that ensure front faces of structures have uniformity. This lot is one of the few that will front the street. And so really we're trying to match a side setback for a lot of the existing houses, which this does. It was determined by reviewing other side yards along houses on 19th Street, because again, most of the houses are facing other streets. The rear yard is adjacent to the rear yard of another property, so there won't be a principal structure directly behind this. And again, in the interest of substantial justice to my client, keeping this lot vacant doesn't secure any public interest. It used to have a house, and having a house will allow development on this lot, which is needed. There's infill development is needed. And so if this variance is denied, we're essentially just an open lot. Please move forward. It's in conformity with the neighborhood. It'll be a single family house. One thing that I'll note that's interesting about this neighborhood, as you could have seen in Lisa's map, is that there's actually R22 MF on the other side of that alleyway. And that's an older development. So it is highly possible in the very near future, given all the growth in Charlotte, that someone could come in, purchase that R22 MF property and construct a very high density development right next door to this property with some pretty, I think up to, I believe it's 4 stories of development. So it's possible that there could be some very high density development next to this property also. And so allowing an infill lot here, that's just more evidence of that this is conformity with the neighborhood, because there's single family houses here. Our plan is based upon what we've done on Walford is a 2-story house. We just don't have the final plan at this point. You can move forward. And that's all my presentation. I'll just ask Carl quickly. Carl, can you please confirm that my testimony, my presentation, that you adopt that as your testimony for this case?
Yes.
Thank you. And I'm happy to answer any questions from the board.
Okay. Thank you, Mr. Murray. Are there any questions for Mr. Murray from the board? Max, you said someone signed up to speak?
That is correct. Miss Class, and she is a panelist, so she can mute and unmute herself. She is opposed to the case.
All right. Ms. Class, before you start, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay. Before you speak, please say your name and your address for the clerk.
Sure. Ashley Massis Class, and I'm the property owner to the right at 1601 Harold Street.
Okay. Please go ahead and make your comments.
Thank you, members of the board, for taking the time to hear my opposition. As I've said, I am the owner to the right of the vacant lot at 1601 Harold Street. My home, deck, and backyard is directly facing this lot and directly impacted to this variance change. As you've seen already, there are the other sections of impact are an alleyway, 19th Street, and adjacent backyard. When I purchased this home in April 2017, I learned from the previous owner that while, yes, there was a 1-bedroom, 1-bathroom that sat there from the 1950s to the 1970s, it was actually the owner of the home, was the relative of the owner of the second home. They had subdivided out the land so that their relative could own property, and they had not separated utilities because at the time of the subdivision. The owner told me that the home was removed because the alley was built and it was encroaching on the alley at the time. If you look at Mr. Murray's 1956 aerial view, it was because that alley was constructed. In that picture, there isn't the alley. When I purchased the home in April 2017, I had reached out to Mecklenburg Tax Records to purchase this lot as it was currently a foreclosed property and it was the original backyard essentially of my property. After 9 months of going back and forth in the auction, I learned that it had been purchased outright by a local investor. Regardless, there's a lot of variances on why I oppose this variance. First, it's not the lot that they're asking for a variance change is not even half of the 7,000 square foot required for the home. The second is that there's a lot of unknowns. The current owner is not building this land. They can't answer the questions because they're looking to make it a sellable lot. They bought this on a tax foreclosure, knowing that it wasn't a billable lot, knowing that they were going to request the variances. They bought it while they did not create the hardship, they bought it currently existing. I have reached out to the lawyer, Mr. Murray, and the owner to possibly purchase this lot as essentially the backyard of the home because it is the smallest lot in over an 8-block radius. And if you look at Polaris, it shows that all the other backyards are currently in line with that section of property. They have explained to me that they are selling it to a builder. So they do not have plans. I do not know if this negatively impacts the neighborhood because of the plans. I don't know what the parking would look like. So overall, my concerns are the unknowns.
Okay, thank you. Is there anything else?
No, thank you.
Okay.
Members of the board, I do have possibly a couple of questions for Ms. Class.
Okay, you can proceed.
Ms. Class, it is correct that you currently rent this property, correct?
Yes, with the intention to live back into the property within the next year.
And you know my client Carl, correct?
I do.
And you had previously said that you wanted to purchase this property, right?
I wanted to purchase the lot for the backyard. Yes, sir. I reached out to both of you.
And there would be nothing that would prevent you if you purchased it from seeking a variance for this lot either, correct?
I'm sorry. I think you're all asking on speculation.
And I think that's kind of what I'm getting to in this situation. Is that it is a separate lot, correct?
Yes.
And previous, when you had stated that the owners knew about the small lot, are you aware that under the statute, you are allowed to purchase property with knowledge that a variance may be obtained?
Yes, I am.
Okay. Members of the board, that's all the questions I have right now.
Are there any questions from the board for Mr. Murray or Ms. Class?
And Mr. Chairman, also, just because this is a quasi judicial hearing, I also have to put my objections on the record to Ms. Class's testimony. I object to the relevancy and calls for speculation about what's going to be built on this property. Obviously, if the front and rear setbacks are granted, this property will still have to be developed within the zoning and development parameters. And so all the other variances that were previously granted for these other lots, I can tell you at least the ones I did on Beckwith and Walford and 17th Street, we did not have construction plans. We did not 100% know what was going to be constructed. So I would ask that it be disregarded speculation about what may be built, because whatever is built, if this variance is granted, would have to comply with the zoning.
All right, thank you, Mr. Murray. Your objection is noted.
And Chairman of the Board, I'd like to object to the speculation questions that Mr. Murray had asked about if I had purchased the property, could I have asked for variances? I think regardless of it, I just want to make sure as the owner that's directly impacted next door that I do not know that it could negatively impact the overall character of the neighborhood at this time, which is why I'm opposing. It's not personal.
Okay, thank you. It's noted. Are there any other questions from the board for any parties? Okay, Lisa, do you have any final comments?
No final comments.
Mr. Murray, you have the final word before we close the hearing. Anything you want to add?
Members of the board, I appreciate your time. I think we've put forward the 4 elements to prove our variance, and I hope you would grant our variance. I appreciate your time.
All right, thank you, Mr. Murray. I will go ahead. Ms. Klaus, you have anything you want to say before I close the hearing?
No, thank you for letting me speak.
Yes, ma'am. Then we'll go ahead and close the hearing, and we'll begin our deliberations. Let's see. Mrs. Dryden, what are your comments? I think you're muted, Mrs. Dryden.
My only reservation is the parking. I know that Mr. Murray showed another lot that used an alleyway for parking, but that you could see where there were trees and it was not a thoroughfare. This one is gravelled for a long, long way. You know, he says it's not used. I don't know. I haven't driven the property. But it seems to me that it does conform to other requests that we've given. And if we don't grant this variance, then it's just a piece of dead property that no one can use. So I'm leaning toward approval of this variance. That's where I am.
Okay, thank you. Ms. Long,
I actually agree with Deborah's comments and inclined to approve it based on staff recommendations.
okay, thank you. Mr. Wilson,
Yes, Mr. Chairman, same here. I do agree with my committees, my colleagues on the committee in regards to this property.
thank you. Mr. Floyd,
I'm struggling a little bit. I think, if you look at the four factors we're supposed to consider, I think there's no doubt that they meet the first three, right? I mean, there's certainly an unnecessary hardship given that the property would not be buildable. It does result from the size of the property. It's not something that the property owner did. So they're clearly, meet those three elements. I think when I get to this purpose, spirit, and intent of the zoning ordinance, I mean, yes, zoning ordinances are intended to, preserve public safety, but they're also intended to help maintain property values, include, aesthetic characteristics of neighborhoods and things like that. And I just wonder if shoving a house on this little tiny lot, I certainly think that is going to have negative impacts for property values, at least on the next door neighbor. And so that's where I struggle. I mean, otherwise, I think they're right, but that issue there, I'm just not sure that they meet that element given the impact that it would have.
understood. I agree with all my colleagues' comments. I understand Ms. Class's concerns about the unknowns, and I don't know what. I don't think there's anything that our board can do to help alleviate those unknowns other than denying the variance. And if we deny the variance, then that property is going to sit vacant. I guess until it comes before the board again at some point, or until the zoning ordinances are changed to allow it to be built without coming in front of the board. Any other comments from the board, or is there a motion?
I move to approve the variance. This is Wilson.
I second. Long.
Okay, we have a motion by Mr. Wilson and a second by Ms. Long to approve the variance. We'll take a roll call vote. Mr. Wilson,
Wilson, yes.
Ms. Long,
Long, yes.
Mrs. Dryden,
Dryden, yes.
Mr. Floyd,
Floyd, no.
Sanderson, yes. Let's look at the findings of fact and conclusions of law.
I make a motion to approve the finding of facts and conditions of law. Dryden.
I second Wilson.
We have a motion by Mrs. Dryden and a second by Mr. Wilson to approve the findings of fact and conclusions of law as written. We'll take a roll call vote. Mrs. Dryden,
Dryden, yes.
Mr. Wilson,
Wilson, yes.
Ms. Long,
Long, yes.
Mr. Floyd,
Floyd, yes.
Sanderson, yes. So those are approved. All right. Our next case is case number 2021-004 for the property located at 16020 Munson Hill Road. Are there any conflicts on this case? Hearing none, it'll be the board members on this case will be myself, Mrs. Dryden, Ms. Long, Mr. Wilson, and Mr. Floyd. Go ahead, Lisa.
Okay, the next case is case 2021-4. It's a residential accessory side yard variance. The applicant is requesting a 2-foot variance from the required 3-foot accessory side yard to construct a tram on his property. And I'll give you a minute to look at your findings.
Go ahead, Lisa.
Exhibit 1 is a vicinity map of the property. Exhibit 2 is a zoning map of the property. The property is zoned R5 single family and is located along Lake Wiley. It's in the lower Lake Wiley critical area watershed overlay. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property, and it shows the 50-foot Lake Wiley watershed buffer from the shoreline of Lake Wiley. Exhibit number 5 is the variance request. The applicant would like to construct a tram in the rear yard to provide accessibility to Lake Wiley. The applicant is requesting a 2-foot variance from the 3-foot accessory side yard to construct a tram. And as you can see on the applicant's survey, the tram will start in the rear yard, and then for 15 feet, it will be encroaching into the 3-foot side setback, and then it will comply after that 15-foot point down to the lake. Exhibit number 6 is a consideration. Staff supports the requested variance. The proposed tram will be constructed within the 50-foot local watershed buffer from the shoreline of Lake Wiley. Charlotte-Mecklenburg Stormwater Services has verified that a variance and mitigation will not be required because the tram is for accessibility and will be impervious construction that does not increase the built-upon area on the lot or require the removal of trees. So they do support the requested variance. Exhibit number 7 is considerations. Further considerations of the request are that the hardship results from strict application of the ordinance and was not caused by the applicants. The hardship results from conditions peculiar to the property. The applicant provided an arborist letter stating that the proposed tram location is ideal to preserve existing trees. There's a 50-foot grade change in the rear of the property, and the applicant states the tram is necessary due to access and mobility issues because he and his wife are no longer able to climb the stairs. And you can see in the aerial to the right, the 50-foot grade change between the home and the shoreline. The requested variance is consistent with the intent of the zoning ordinance because the proposed tram is an impervious rail system that does not increase the built-upon area of the property. Exhibit number 8 are photos. To the top left is the home, and then to the right of that is the private drive. There's several homes that are accessed off this private drive. And then the applicant has provided photos of the proposed tram and what it will look like, and those are at the bottom, the 4 photos on the bottom of the screen. So that's my presentation. If you have any questions for me.
Thank you, Lisa. Are there any questions for staff?
I have a question. Can you go back to the plot plan that shows the location of the tram? So is there a reason that it can't all, I think you said how many feet encroach, right? Until it complies?
So it encroaches for the first 15 feet, and then it complies with the 3-foot side yard. And the applicant states that that's because of existing trees on the property.
Yeah, that was my question, is why couldn't it be moved over to comply for the whole length of the tram?
Okay. Any other questions for staff? Max is the property owner on the call.
Yes, the property owner is on the call and he should be unmuted. Brian Hatfield.
Yeah. Good morning,
All
board
right.
members.
Good morning, Mr. Hatfield. Before you make any comments, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay. Please state your name and address for the court reporter, please.
It's Brian Hatfield, 16020 Munson Hill Drive.
Okay. Thank you. Please go ahead and present any comments or.
Sure. Yeah. I'll just add a couple comments. So that is correct. The 2-foot variance is being asked because of a very large tree that's in the way, so to speak. We'd like to preserve the tree. So that is the reason for the variance itself. Obviously, the tram is used for mobility purposes, about 120 feet. It's a very, very steep facility, and it will allow us, as we age, to be able to use our property. My neighbor, Harley Green, is also, I believe, here on the call too as well. He's the property owner that where the encroachment would take place, and he's approving or supporting this variance and not taking down the trees, as well as our HOA. We would like to preserve our beautification of our property, so we really don't want to take down a tree in order to build this tram. So again, that's the reason for the variance, and I do have support of my neighbor.
All right. Thank you, Mr. Hatfield. Is there any, Max, is there anybody that wishes to speak for or against?
I believe the neighbor, Mr. Green, is the only person that signed up to speak. I did receive opposition from one neighbor, but they do not appear to be on the call.
Okay, Mr. Green, would you like to speak, or are you
Yeah,
good
I'm
with?
here, and I would be happy to speak.
All right. Before you start, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right. Please state your name and address for the court reporter before you make any comments.
Good morning. My name is Harley Green, and I live at 16016 Munson Hill. And that is the property that is adjacent to Brian Hatfield, and would also be the property that is on the side of the property where the tram is intended to be located. I have been in discussion with Mr. Hatfield on this proposal for the last several months. I agree the backyard, from the houses to the lake, it's a 50-foot elevation change. It's about 22 degrees an angle or a 40-degree slope. So it's a pretty strenuous hike up from the water. And as you can imagine, these houses were purchased with the intention of taking advantage of the waterfront access. So, that my perspective is that it's a good investment in the value of his property, and good for him to continue to make use of the waterfront access that he, intended when he purchased the property. That's it. I would conclude with that.
All right. Thank you. Are there any questions from the board for the applicant or Mr. Green? Okay, Lisa, is there any final comments from staff?
No final comments from staff.
Mr. Hatfield, any final comments?
I do not, and I thank the board.
All right, thank you. We'll go ahead and close the hearing then and begin our deliberations. Let's go ahead and start with Ms. Long.
I'm in support of this.
Okay, Mr. Wilson,
Same, I'm in support of this. I'm in support of approving this variance.
okay, Mr. Floyd,
I agree. I'll support it.
Mrs. Dryden,
I too support this, especially since the neighbor spoke up and said he has no problems with it and it only encroaches for 15 feet. So I think it's a good variance approval.
okay, I agree. So is there a motion?
Dryden, I make a motion to approve the variance.
Long second.
We have a motion by Mrs. Dryden, a second by Ms. Long to approve the variance. Take a roll call vote. Mrs. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mr. Floyd,
Floyd, yes.
Anderson, yes. Approved. Let's look at the findings of fact and conclusions of law.
I make a motion to approve findings of facts and conclusion of law.
I
Thank you.
Wilson.
Thank you. We have a motion by Ms. Long and a second by Mr. Wilson to approve the findings of fact and conclusions of law as written. Take a roll call vote. Ms. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mr. Floyd,
Floyd, yes.
Mrs. Dryden,
Dryden, yes.
Anderson, yes. All right, our last case on the regular agenda is case number 2021-020 for the property located at 11600 Old Surrey Lane. Lisa, you can go ahead and start.
The next case is case 2021-20. It's a residential setback variance. The applicant is requesting a variance from the 55-foot required setback along Williams Pond Lane to construct a pool. And I'll give you a minute to look over your findings. The findings do include the requested variance that staff does not believe meets the criteria for granting a variance, and also a modified request that staff could support. And you'll find the information on the modified request after the requested variance information.
Okay, Lisa, before we get started, are there any conflicts for the board member, any board members on this case? Okay, hearing none, let's keep the board members to myself, Mrs. Dryden, Ms. Long, Mr. Wilson, and Mr. Floyd on this case. You can go ahead and proceed, Lisa.
Okay, exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R3 single family. Exhibit number 3 is an aerial map of the property. You can see the property has 2 frontages, one in the cul-de-sac of Old Surrey Lane and the other along Williams Pond Lane. Exhibit number 4 is a close-up aerial map of the property. And exhibit number 5 is background of the property. The property was subdivided in 1986 and shows a 55-foot setback from Providence Road West, which is now called Williams Pond Lane. Since the setback and rear yard both abut streets, the rear yard is the same as the required setback in the district. The setback for the R3 zoning district is 30 feet, but the plat shows the 55-foot setback, which supersedes the required zoning setback. So 55 feet would be required along Williams Pond Lane. Slide 6 is the variance request. The applicant applied for a pool permit to locate a pool 17 feet from the rear property line. The pool permit was not approved by zoning because it encroaches into the 55-foot required setback from Williams Pond Lane, and no principal or accessory structures are permitted within a required setback. The applicant is requesting a 38-foot variance from the 55-foot setback to allow a 17-foot setback from Williams Pond Lane. However, no survey has been provided to confirm the measurements, so staff is uncertain of the exact variance needed. The survey provided or site plan is not to scale, so we're not exactly sure what variance is needed for the pool. I've labeled on the right side where the property line is and the 17-foot to the water area of the pool, which is how we measure the distance of the pool. Slide 7 is a consideration. Staff does not support the variance as requested since it encroaches into the setback shown on the plat, as well as the minimum 30-foot setback required for the R3 zoning district. Also, there's compliant area on the property where the pool can be located to the left side of the home. Slide 8 is further considerations. The hardship is caused by the applicants. The applicants state they were not aware of the 55-foot setback requirements until the permit was denied, and the pool location can be made compliant with zoning requirements. The hardship does not result from the strict application of the ordinance because there is compliant building area on the property to locate the pool. Also, the requested encroachment can be lessened and still accommodate the pool construction. Granting the variance will not change the character of the area. The encroachment wouldn't be easily detectable because there's a fence, vegetation, retaining wall, and 4-foot grade change along Williams Pond Lane. And granting the variance would not impact public safety. Staff would support a modified variance of 25 feet from the 55-foot setback to allow a 30-foot setback along Williams Pond Lane. This would be consistent with the spirit and intent of the zoning ordinance, since 30 feet is the required setback for the R3 zoning district. Since the time of plat recordation and home construction, the I-485 interchange analysis plan for improvements along Williams Pond Lane have been installed. The permitted building areas for the accessory structures is decreased for the property because of the Williams Pond Lane frontage. Without that frontage, the applicant would be permitted to locate an accessory structure up to 3 feet from the side and rear property lines in the established rear yard. The applicant has not indicated their agreement to the modified variance request. Exhibit number 10 is a photo of the property. And that's my presentation. If you have any questions for me.
Thank you, Lisa. I have a couple of questions. I think it was the 2 or 3 slides before that had a picture to the bottom right. No, the one you just passed, the one that had the pool.
Okay.
Was that the one showing the pool? Is that the actual property with the pool under construction?
Yes.
So construction was started before approval of a variance?
Before permit approval, yes.
Okay. And they haven't replied concerning the modified variance the staff would recommend.
They replied for clarification, and we gave them clarification that a survey is going to be needed to look at the exact dimensions and that we could support the 30-foot setback along Williams Pond, but no further than that, because that's the required setback for the district, and they did not respond after that time.
So would it be, I guess this might be a question for Jill. Would it be appropriate for us to continue this case until they submit that a survey showing these dimensions that are required by staff to make a decision?
Is the applicant present? Can I ask that first?
Yes, the applicant is present. They're panelists, so they should be able to mute and unmute themselves.
All right. Mr. Hitchman, before you, I guess I should let you go ahead and do your presentation before I start getting into those types of questions. I apologize. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
All right. Will you please state your name and address for the court reporter, and then you can make any presentation you want to make.
11600. Sorry, Neil Hitchman. Do it the other way around. Neil Hitchman, 11600 Old Surrey Lane in Charlotte, North Carolina.
Thank you. You can go ahead and proceed with any comments or presentation.
No, I wanted. Thank you for hearing the case. Obviously, we got caught here. We assumed our pool company had done the a permit, as you called it, and we got caught here, and that's on us, unfortunately. But we're just trying now to understand what the options are, because we're at that point, as you can see in the photograph, trying to understand that the requirement of a 55-foot setback is our whole backyard completely. So it's really not easy for us. There is a side piece, but that's difficult to fit this in, I think, with everything else that's there, but that's another issue. So yeah, at first, obviously, we'd love you to listen to the position it's in now. And if that's not the case, then what I think you said you would accept a variance of 25 feet to 30 feet from that. And obviously, we'd be interested in pursuing that. We would have to move the pool to comply with that. So it's not easy for us, I'll be honest. But yeah, that's really the details.
Okay. So would it be possible for you to get a survey that shows the actual on-the-ground dimensions for staff to review it and try to help alleviate this situation before this board has to make a decision one way or the other?
Yeah, we thought we'd done that. And again, this is another mistake. I'm not making a very good case for myself here, I guess, but we paid for a survey, which was what you received. We thought that's what you received, but it turns out that they didn't even have the 55-foot setback on it. So we're chasing another survey right now. So we're just trying to work out now what our options are. If the option is to have to move it, we kind of would like to know that. That's the only thing I would ask, because obviously having a pool sat in there without the flow is not good for the area around it in terms of insects and stuff like that. But yeah, we can certainly get one. We're chasing one, but we haven't got one, and one official one, I guess you'd say, at this point. And I apologize, we paid for one and it just didn't have the right,
right,
whatever.
Yeah, I understand. Lisa and Shad, would that be, if they get a survey and get you that information, would that be something that you could look at and see how it fits versus how your modified plan would fit?
Absolutely. We would love to see a sealed survey so we can see those exact dimensions of where that pool is sitting.
And maybe be able to take care of this without it coming in front of the board?
Well, in order to encroach in that 55-foot setback, it's still going to have to come before the board.
Right,
And I'm
okay.
pretty sure it's going to encroach there, but we would be in support of it if it doesn't exceed the 30 feet.
But right now, you don't have all the information you need to make a decision in a way that the staff could recommend it.
Correct, because it appears that it may not be encroaching into that 30 feet, or it may be close. We don't believe that the survey submitted is scaled, so we can't really know yet until we get that information.
Okay.
I don't know if I'm allowed to speak again. Is it okay?
Yeah, I was getting ready to come back to you. Is that, Mr. Hitchman, is that something that you're willing to get staff that sealed survey so that they can make a decision, and maybe you are within that 30 feet and maybe you wouldn't have to do anything. I don't know, because they don't know the dimensions right now.
I guess what I would ask is this, and maybe you guys can tell me I'm out of order, that's okay, is maybe if you could grant what variance you think you can live with, and then when we get the survey, if it doesn't grant, I can move it. Just would save another round of coming before you guys if possible. That's just a request. I don't know if that's even possible.
I'll have to defer that question to our attorney, Jill.
And I'm actually, I would like for Tari to weigh in from Stoning's perspective. And I will say that if the applicant is modifying his variance request, the board can certainly vote on that today. But as far as coming back,
Right. Yeah, I think that there has to be some specificity around what the exact variance request is. And it doesn't sound like we have that now. And I understand that the applicant is willing to take whatever the board will give him. However, there has to be a specific variance request being considered by the board. Once the board considers the specific request, it can obviously grant less than is being requested. But I think that you have to have some specificity here, and the survey would help with that.
Am I incorrect saying that the board we can't approve a setback just because that's what we think it may be, or what it has to be, without the information that's needed from that survey, because then it may come back before us again because it won't work. Is that correct? We have to have a request for an actual dimension, and then.
That's right. That's right. That's exactly right, Rick.
And we're not the ones making the setback. We're the ones that are reviewing it and approving it. So,
I wasn't asking for an open-ended one. I was asking for the 55 to change to the 30.
If you wish to make the request to modify your variance request to a 30-foot setback, the board can review that and make that decision. And if that's approved, then you would have to work with staff and your contractor and building permits to come within that 30-foot setback or receive a notice of violation. Is that correct, Tari and Jill?
That's correct. And I'd like to hear from staff because, I'm usually they have spoken with the petitioner and worked to get this variance request before you. So I'd like to hear from staff about their opinion about going forward.
I would prefer to see a survey, just because if you look at the exhibit number 6, to the left is 17 feet to the surface water of the pool to the property line. But if you look, the home is measured as 37 feet, and it doesn't look that different. So the variance request that's needed may not be as small as 30 feet. We would support down to 30 feet if that's what it is, but it would be better, in my opinion, if we could see a survey.
Then should we go ahead and continue this case until a survey can be submitted to staff?
It seems, Rick, Mr. Chair, so that you could get some exact dimensions, that would probably be the prudent course of action.
Okay, is there any, Mr. Hitchman, is there any concern of yours to continue the case? I know you don't want to come back before the board again, but right now the board staff just doesn't have enough information to make a recommendation to the board. And if it is, after the dimensions are provided by a sealed survey and you and staff can work out the final details of where it needs to be and where your pool needs to be, and it may be able to just go on the recommendation agenda. You wouldn't even have to come back before the board. It would just be a recommendation agenda item at that point, and you may not have to move the pool at all. We just don't, staff doesn't have enough information to make that decision or recommendation to the board. But do you have a problem with doing a continuation for a month or 2 months until you get that survey into the staff's hands?
It's only having a big thing of water in the backyard. Obviously, it's a breeding ground for things, but let me see what I can do.
Yeah, I understand that. I mean, you can light a fire under your under a surveyor and get it done pretty quickly, I would imagine. But that's up to, I don't know who you're using, but if that's what, I mean, I think that's the prudent case for everybody involved. Because once the board makes the decision, it's the next step for you is to, if you don't like it, is to go to the Superior Court. And everybody involved would prefer to get it resolved and you be able to move on and staff can move on and the board can move on without having to deal with that. So.
Okay, it doesn't look like I have an option, so okay, thank you.
Well, you do have an option. If you want us to make the decision today, then you can live with that decision.
No, that's fine. I'll try and get it. I've been trying to get it, to be honest with you, but I kind of found out a little late.
All right, well, I understand. Does the board have any issues with us having a continuation of this case?
And Mr. Chair, I would recommend that the board proceed with a motion and vote on the continuance.
Yeah, I was getting there. Is there a motion from a board member to do a continuance of this case until the applicant can provide a sealed survey to staff for a final review of this to come back on the agenda?
Yeah, this is John Floyd. I make that motion.
Dryden, second.
Thank you, Mr. Floyd. So we have a motion by Mr. Floyd and a second by Mrs. Dryden to continue this case until the applicant provides a sealed survey to staff for a final review and recommendation to the board. Hopefully at the next meeting, that can be done. But Jill, do we need to put a time frame on that?
Mr. Chair, I would say that you could leave it to the board. I mean, I'm sorry, the staff to schedule it as soon as they receive the survey, as soon as practicable.
Okay, and we'll leave it. So the motion is to have a continuance of this case number 2021-020 until the applicant provides a sealed survey to staff for review and final review and recommendation to this board as early as practicable for the next board meeting that's practicable for the staff. And we have a motion by Mr. Floyd, a second by Mrs. Dryden. We'll take a roll call vote. Mr. Floyd?
Floyd, yes.
Mrs. Dryden?
Dryden, yes.
Ms. Long?
Long, yes.
Mr. Wilson?
Wilson, yes.
Anderson, yes. So that case is continued. All right, we have an adoption of findings of fact. Before I get to this case, which is case number 2020-032, Max, can you tell me which board member sat in on this case?
I can get you that in just a minute. I don't have it in front of me right this second.
All right. If you could do that, I would appreciate it. Is Mr. Powers, has he joined us?
Mr. Sanderson, yes, Mr. Chair, I am on the call.
All right. Morning, Thomas. How are you today?
Doing quite well, Mr. Chair. How are you?
I'm doing well, thank you. Before
Mr.
you start, I wanted to see what the board members, who the board members were who sat on that case, and if we can. I think Mr. Brown may have been on there, so we may have to have another board member. But does that make a difference, Thomas?
No, I do know Mr. Floyd will need to recuse from this case based on a previous email between himself and me. I do not believe that having new board members actually adopt the findings of fact will be an issue. Each member of the board has already received a copy of the record from the previous hearings to have an opportunity to read and review. So long as we've read all of that, I think we can proceed to move forward with an adoption of findings in this regard.
Okay, then based upon that, let's have myself, Mrs. Dryden, Ms. Long, Mr. Wilson, and Mr. Cota.
And I have the members that heard the case now.
And who would those be, Max? Just out of curiosity.
Yes, it was Mr. Sanderson, Mr. Brown, Ms. Dryden, Mr. Welch, and Ms. Allen.
All right, well, 3 of those members aren't here, so we'll have to go with the 5 I just said.
Mr. Chair?
Yes, Mr. Powers.
Mr. Cota did not receive the actual record on appeal from the Zoning Board of Adjustment, so he cannot be a part of the actual discussion since he has not had an opportunity to read the actual information prior to taking a vote. I think in this instance, we can go with the current 4 members of the board and take a vote on those findings of fact.
Okay, if you are fine with the 4 board members of myself, Mrs. Dryden, Ms. Long, and Mr. Wilson, and if you think the Superior Court judge will be fine with the 4 board members, then I will go with your judgment.
One moment, sir. And just, Mr. Chair, can you please read off the names one more time?
It'd be Mr. Sanderson, Mrs. Dryden, Ms. Long, and Mr. Wilson.
Yes, okay, that's fine. Again, those 4 individuals have received the actual record, so I think we can move forward with those 4. Again, we're solely adopting the actual findings of fact in this case. So that is the only thing that we're actually doing at this time. Just to make sure, again, for purposes of the board, I will explain why we're in the position that we're in at this moment. As the board is aware.
And it is my understanding, Mr. Powers, that this is strictly to approve the findings of fact and conclusions of law. The hearing will not be reopened. There will be no additional testimony or presentations by staff or applicant or outside parties.
That is correct, sir. Yes.
All right, then I turn the floor over to you, Mr. Powers.
Thank you, Mr. Chair. Members of the board, again, I am Thomas Powers from the City Attorney's Office. You may be aware, again, from having an opportunity to review all of the materials that were provided to you, that this case was previously presented to the Zoning Board of Adjustment, and the Zoning Board of Adjustment moved to deny the variance in that request. The actual applicant, Mr. Talibi, then appealed to the actual Superior Court, and the Superior Court has looked at and reviewed the actual decision of the Zoning Board of Adjustment and effectively found that the board was not able to properly articulate its actual findings of fact and conclusions of law, but found that if it had documented all that information properly, it would have affirmed the decision based on, again, a whole record test and application of a de novo review under the law. As such, the judge remanded this matter back to the Zoning Board of Adjustment for an adoption of findings of fact related to this case that clearly articulates its reasoning and position in regards to the facts and or matters before it at that time. You have already been presented with the actual proposed and revised findings of fact and conclusions of law. I believe you've all had an opportunity to review that. Before we move forward, I am going to just confirm again, A, that you have received the actual proposed findings of fact and had an opportunity to review, and B, that each and every one of you has individually reviewed the materials in question and can affirmatively state on the record that you have done as such. So with that being said, the first question I would need each person by roll call to affirmatively state is that you have received the proposed findings of fact before we move to vote on those. Mr. Sanderson.
Yes.
Mr. Wilson.
Yes.
Ms. Long.
Yes.
Ms. Dryden.
Yes, I received the finding of facts.
And I'm missing one person's name.
We only have 4 board members.
Right. Okay. I do have everybody. All right, just double checking. All right. And the second question that I want to verify as well is that each of you have had the opportunity to review the entire record as provided to you. Mr. Sanderson?
Yes.
Mr. Wilson?
Yes.
Ms. Dryden?
Yes.
Ms. Long?
Yes.
All right, being that, and I greatly appreciate you affirmatively stating this on the record. With that being said, being that you've had the opportunity to receive the actual proposed findings of fact and had the opportunity to review the entire record, the City Attorney's Office is asking for the Zoning Board of Adjustment to adopt the revised findings of fact as presented. If there's any questions that you may have, again, I am here to answer those questions for you at this time. But as the chair alluded to earlier, we're in closed deliberations and discussions at this point. There will be no testimony or input or any commentary for anyone in the public related to this case. This is only an opportunity for the board to ask questions and to receive answers related to, again, the request to adopt the proposed findings of fact. Mr. Chair, I turn it back over to you.
Thank you, Mr. Powers. So are there any questions concerning the revised findings of fact and conclusions of law from the board? If there are none, I'll give you a moment, but if there are none, is there a motion to approve the revised findings of fact and conclusions of law as presented by Mr. Powers to the board?
Dryden, I make a motion to adopt the revised finding of facts and conclusions of law for case number 2020-032.
Long second.
We have a motion by Mrs. Dryden and a second by Ms. Long to approve the findings of fact, the revised findings of fact and conclusions of law as presented by Mr. Powers. We'll take a roll call vote. Mrs. Long. Ms. Long.
Long, yes.
Mrs. Dryden.
Dryden, yes.
Mr. Wilson.
Wilson, yes.
Sanderson, yes. Those are approved unanimously. Mr. Powers, is there any other business that we need to deal with this case today?
Not at this time, Mr. Chair. Upon the adoption, again, we'll go through our normal protocol and procedure to have Mr. Spencer as well as you, Mr. Chair, to sign the necessary information. Jill Sanchez Myers and myself will work on the necessary steps with the applicant and the necessary party to move forward in this matter.
All right, thank you.
Thank you, sir.
Our last item to deal with today is the approval of the February meeting minutes. Has everybody had a chance to review the meeting minutes? And if so, is there any revisions or is there a motion to approve?
I'll make a motion to approve the minutes.
Thank you. Is there a second?
This is Floyd. I second.
Thank you. We have a motion by Ms. Long, a second by Mr. Floyd to approve the February meeting minutes. We'll take a roll call vote. Ms. Long.
Long, yes.
Mr. Floyd.
Floyd, yes.
Mr. Wilson.
Wilson, yes.
Mrs. Dryden, Mrs. Dryden,
Oh, Dryden, yes. I apologize.
thank you, and Sanderson, yes. So those were approved. Lisa, Shad, Jill, Tree, is there any other business the board needs to deal with to take under advisement today?
Nothing from staff.
All right, then we'll go ahead and adjourn the meeting of the March Zoning Board of Adjustments. Thank you, everybody. Have a good month.
Thank you.
Thanks.
Thank you.
Thank you.
Jill and Therese,
Yes.
could you both stay on for a moment, maybe Shad as well?
Sure.
Okay.